295 State versus Luis Beltran. Can I have parties approach and announce for the record?
Before this hearing begins, it is essential to understand a key point. This is not a routine court appearance. It is a serious legal dispute focused on jurisdiction, judicial authority, and the structural basis of criminal court proceedings. The defendant is charged with aggravated robbery, a felony offense. Rather than addressing the factual allegations, he has submitted multiple jurisdictional challenges, questioning whether the court has lawful authority to try him. That issue immediately increases the stakes because jurisdiction is not a minor procedural detail. It is the legal foundation of any criminal case. The terminology used in his motions, phrases such as abstract subject matter jurisdiction, third-party waivers, and de facto court, reflects a strategy sometimes seen in unconventional defenses, where the legitimacy of the court is challenged instead of the substance of the charge. In a felony court, however, the judge's primary duty is clear: to determine whether the indictment, the felony classification, and the location of the alleged offense establish proper jurisdiction under the law. The judge is now preparing to address these matters carefully and methodically. Her analysis is not emotional. It is grounded in procedural rules, the penal code, and the grand jury process. The central question becomes whether the defendant's arguments stem from a genuine misunderstanding of the law or from a calculated effort to delay the proceedings through procedural objections. If jurisdiction is properly established, each of these motions may fail immediately. The court's response will be decisive.
Arlene Gay is the defendant.
All right, and are you Mr. Beltran?
Yes, Your Honor.
All right, in defense, you said you've adopted his motions?
Yes, Your Honor.
All right, so the first motion is a motion for a special appearance under the authority of Texas Rules of Civil Procedure 120A for the divine purpose of objecting to the de facto district court's abstract subject matter jurisdiction, non-ex parte third-party waivers allowed. So let's address that motion.
Yes, Your Honor. My client's position is that that there is a defect in the abstract subject matter jurisdiction, that he has been brought into this improperly because the state would be the plaintiff, and they brought him in and are litigating that, and that there's a jurisdictional issue, that the court does not have in persona or subject matter jurisdiction.
All right, is there a response, Sate?
Judge, as a criminal district court, the court does have jurisdiction to preside over any matters. The defendant has been charged by indictment with the offense of aggravated robbery, and that occurred in Dare County, Texas, and so the court retains jurisdiction over those proceedings.
All right, so Mr. Beltran, anytime that there is a criminal case that's deemed by the penal code to be a felony, then that comes to a felony criminal court. All right. And then the next question becomes whether or not a grand jury has been given evidence. You've been indicted, so they've been presented with information, right? And if it's alleged that the incident occurred in Bexar County and it's a felony, then I would have jurisdiction over the case. So if for some reason this was a case that is alleged to have happened in another county, let's say it's Hayes County or Harris County, then I wouldn't have any jurisdiction over it. Do you understand?
Mm-hmm.
All right. So with this case, I'm not taking any of it to be true because I have to wait till evidence is presented to me. But looking on the face of in the indictment, and I'm sure your attorney will tell you, an indictment is not evidence of guilt. It's just the means whereby a person is held over for trial, right? And so when a grand jury indicts a case, they're just saying there's enough evidence to hold you over for trial. They're not saying it's evidence beyond a reasonable doubt. And when information is taken to the grand jury or evidence, police reports or whatever it may be, In it, it has to be allegations that it happened in Bear County. In it, it has to be allegations that it's a felony. Now, if this were not alleged to be a felony, then it wouldn't be in this court. Even though it would be a criminal case, it would be sent to a misdemeanor court maybe, or perhaps even a municipal court. But because aggravated robbery, according to the penal code, is a felony, it's supposed to be in a felony court.
The judge's explanation at this stage is highly significant and serves as a clear demonstration of how criminal jurisdiction operates. She draws an important legal distinction: an indictment is not evidence of guilt. It is the formal charging instrument that authorizes the case to proceed to trial. This clarification corrects a common misconception reflected in the defendant's arguments. She further explains that aggravated robbery is classified as a felony under the penal code. As a result, jurisdiction properly lies in a felony district court when the alleged offense occurred within the county. The court is not required at this point to prove that the crime occurred. It must only confirm the existence of a valid indictment alleging a felony within the appropriate geographic boundaries. The judge's tone remains composed and instructive. Rather than responding defensively to the complex phrasing of the motions, she translates the governing law into straightforward and logical terms. Such clarity often reflects confidence in the court's lawful authority. From a procedural standpoint, this explanation substantially strengthens the prosecution's position.
And it happened in Bear County, then it would come to a felony district court, state district court that's in Bear County. And that's where we are. You understand? Is there anything you not understand about my ruling on that? All right, thank you. And then we have, Yes.
Excuse me, did the court take judicial notice of the indictment in this case?
yes,
Make its ruling, okay.
yes.
The
And
other,
then the next we have new discovery of ex parte corpus trust fraud upon the court that conceals the facts that the charging instrument lacks subject matter controversy. No injury in fact exists.
Your Honor, I believe what my client meant by that is just kind of coupled with the first paragraph, that the court his position was the court didn't have jurisdiction, the court just ruled that they did. That then the indictment would not be valid in this case. So I think that's what the client is trying to say.
All right,
Did I get that right?
Yes.
Okay.
all right. So State, you want to address the issue and what and if I'm interpreting this incorrectly, let me know, okay? So you are saying that the offense, that there is no subject matter jurisdiction because there's no injury by any party?
Yeah.
All right, so if you can address that.
Your Honor, this case was presented to a grand jury that was duly impaneled. They indicted the case. They returned a true bill of indictment. The indictment does comply with the penal code and the code of criminal procedure, which governs in this case. And it does allege the requisite elements for the aggravated robbery. And so it's a threat by using a deadly weapon. And so that is the harm. The crime was committed against the peace and dignity of the state, and there is an alleged complainant.
All right, so Mr. Beltran, do you understand with the charge of an aggravated robbery case, sometimes it's alleged that a person maybe pulled a knife on somebody and said, give me your money, right? I don't know any of the facts about your case. The only thing I can do is look at the indictment, right? And then sometimes it's alleged that somebody pointed a gun at somebody and said, give me your money. The way indictments work is if it is a crime in the penal code, and there's a list in the penal code of all the crimes, and aggravated robbery is one of those crimes that's listed in the penal code, and it sets out what the elements are of that. Now, you're saying that there was no injury in fact exists. The only thing the state has to do is prove the elements that are in the indictment, and the indictment has to show the offense that is in the penal code. You understand? So, do you understand? You gonna have any questions about the court's ruling? All right, if there's something you don't understand, let me know, all right? And I understand that sometimes when people have been to law school, like for example, I haven't really worked on cars. So there's a little stuff I can tell you about being a mechanic, but I really don't know the ins and out of every vehicle. You understand? All right, so number 3, defendant is erroneously charged with an abstract offense. C, I don't know, I can't read that word. Something taxation. District court is criminally attempting to receive an unauthorized, colorable, no fault immunity third-party benefit in violation of the 7th Amendment. All right, do you want to address that, counsel?
Yes, I believe my client, I think it just goes back to, being a third party brought in here without, abstract subject matter jurisdiction. And, the fact that he was brought into this case. I believe that's it. Is that it? Okay.
All right, State, do you want to respond?
Judge, regarding, I guess, the 7th Amendment applying in the case, or, okay,
Yes.
that is for civil suits. We are in a criminal court, and so I would argue that that does not apply here.
Mhm. All right, so the 7th Amendment applies to jury trials that you're entitled to, and that is in federal civil cases. Here, you do have a right to a jury trial if you want a jury trial. And if you want a jury trial, I'm going to make sure that you have a jury trial, okay? And then the other issue, let me see. I don't understand when you say, explain it to me, you're saying district court is criminally attempting to receive an unauthorized, colorable, no fault immunity. What do you mean by that? Because what I can tell you is I don't receive anything related to these cases. Of course, as a judge, I'm paid a salary for the work that I do, but I don't receive any funding or extra funding based upon how I resolve cases. Do you understand? Do you have any question about that?
No, ma'am.
All right, so then the other one is dishonest services that rises to constitutional tort and national security concerns, communist activity detected in violation of Title 50 USCS 841. This court now under federal questioning under Title 28 USC 1331, light of new evidence investigation hypothetical claims. All right, defense.
I'm not sure what my client means by that. I'm gonna ask him to explain it.
All right, if you could explain that to me, Mr. Beltran.
I guess what I'm trying to say there, Your Honor, is how the state of Texas is plaintiff. And they're the ones that are pursuing and to prosecuting me,
Mhm.
which is they're one of third party,
Okay,
and I'm not. I don't. Third party, I'm not sure how that works. I know
Okay.
how civil suits, and I know it's criminal law, but I know that. I mean, how can I cross-examine the state of Texas? How can I?
so let me explain something to you. Whenever you see cases on the criminal side, it's not individuals versus individual. Usually when you're on the civil side, if it's a marriage, it's individual. If it's civil. All right, here, the reason why it's the state of Texas is because in criminal court, it's not you versus the complainant. Whoever the complainant is in this case, that you're accused of committing aggravated robbery against? Yes, it's alleged to have happened that you committed aggravated robbery against them. But the state of Texas, the way we were taught in law school, the state of Texas takes offense, right? Because whenever an offense is committed against a citizen, it's the offense against the citizen, but it's also the offense against the state of Texas. So in cases such as these, the state necessarily is not the complainant. They're just bringing the suit or the case because the state of Texas is offended that an offense is alleged to have been committed within the state of Texas, within the county of Bear. So that's why the state of Texas is listed and not the complainant. Do you understand?
Yes, I understand that. And so how do I cross-examine the state of Texas?
The state of Texas.
This portion of the hearing is particularly revealing. The defendant questions how he may cross-examine the state of Texas, demonstrating a fundamental misunderstanding of criminal procedure. In a criminal prosecution, the state is not a witness. It is the sovereign authority acting on behalf of the public. The judge explains that cross-examination applies to individual witnesses who provide testimony, not to the state as a legal entity. In doing so, she addresses several misconceptions simultaneously: the function of the state, the concept of injury in criminal law, and the structure of prosecution. Unlike a civil case, a criminal prosecution does not require a personal injury claim by a private party. The alleged violation of the penal code itself constitutes an offense against the peace and dignity of the state. This principle is central to criminal jurisprudence. At this moment, the tension in the courtroom becomes analytical rather than emotional. The discussion focuses on legal structure and doctrine rather than confrontation. The remaining issue is whether the defendant is sincerely confused about criminal procedure or deliberately interpreting the matter through a civil law framework. That distinction may later affect how credibility is evaluated.
Cross-examine them. The persons you would cross-examine would be any witnesses the state of Texas would call to try to prove that you've committed an offense against the sensibilities of the state of Texas. So, for example, for an aggravated robbery, they'll need to call somebody to prove that it happened in Bexar County. They'll need to call somebody to prove that it happened on or about whatever date it is. If there's a weapon used, they'll need to call somebody to prove that a weapon was used. And they may need to call a complainant to say, hey, I'm the person in your indictment. You
I
understand?
understand, Your Honor.
All right. Do you have any questions or any confusion? All right.
May I ask my client a question before you go on to next? Are there any other things in here? Because some of it repeats itself. Were those the main points?
Other than anything.
Or is there anything else in your motion that are different that we need to bring to the court's attention that would be different?
All right. So then with regards to that motion that's combined from page 1 to page 6, then the ex parte relief requested will be denied. Now, by denying that, that doesn't mean that if there's a jury trial, your attorney still will not have the opportunity to question whatever witnesses the state calls, okay?
Understood.
So that will be denied.
There is it appears to me that there was like 3 separate documents stapled together. Is that the way it was received?
Yes.
There is the next one, which is exhausting administrative relief.
Mhm.
My client is not wanting to have that heard, right? It deals with ineffective assistance of counsel. Right, Mr. Beltran, that's not to be heard right now?
All right, and let me explain something to you. I understand that's not to be heard right now, but what I can tell you is attorneys who are appointed to represent people, those are attorneys who are on the wheel for appointments, right? And if this is a first-degree felony, just from the face of what I'm looking at, And if Ms. Gay wasn't qualified according to the qualifications to be on the will for first-degree felonies, she would not have been appointed to represent you. Do you understand?
Understood.
And Ms. Gay, are you on the first-degree will?
Yes, I am.
All right.
So the next document is entitled, Court Constitutional Notice.
Mhm.
And that addresses antitrust violations, fraud upon the court, actions of the state bar.
All right. Do you want to take these one at a time, counsel?
I guess so, Your Honor.
All right. The first is new discovery of antitrust violation lies, fraud upon the court, elected state bar officials, seditious organization are conspiring to fraudulently conceal the ultimate fact, Sixth Amendment misconduct, that the state bar of Texas lacks capacity to prosecute a natural person. It is an improper plaintiff. All right, so with that, I can tell you, the State Bar of Texas is not prosecuting you. The State Bar of Texas is more of an affiliation that attorneys are required to belong to. And we actually have to pay state bar dues every year. And when that comes around every year, everybody's like, oh my gosh, state bar dues.
Student.
Yes. So the state bar is not participating in this trial. Now, I can tell you as an attorney, your attorney as an attorney, and the state as an attorney, anyone who's licensed in Texas, they're required to be a member of the State Bar of Texas, and they have to pay dues to the State Bar of Texas. I think it's $265. It may have gone up. All right, so they're not going to be trying you.
Yes, sir, Your Honor.
All right, the next one is state bars, virtually gathered evidence, video, police reports, third party. Again, what I can tell you about that is the state bar hasn't gathered any evidence. State. do
I
you
think
know-
I just put, I'm sorry, Your Honor.
Yes.
I think I just put that as.
All right, so do you want that heard or no? All right, and then the next one is, so to permanently prevent a false state bar, anything with regards to the state bar, do you still want that heard or no? It says objects to Texas State Bar ex parte matter waivers and fictional double jeopardy defective jurisdiction. Do you want that heard?
Yes.
All right. Defense?
My client believes that, again, that the court does not have jurisdiction, that he is concerned about his waiver of his constitutional rights. Some of this deals with what happens at trial, like hearsay evidence being admissible, being admitted wrongfully, and that he still believes he's a third party, and that there's abstract jurisdiction, and that the court doesn't have the power, I'm guessing, to rule on evidentiary issues such as 901, and that, in other words, probable cause is third party fabricated, then secretly planted and dressed up to appear that it has merit, but it does not. So he is talking about one jurisdiction and also trying to state his right to object to evidence.
All right, State, do you want to address that?
Regarding the collection of evidence, I'm not sure.
Oh, no. So, let's address double jeopardy. Double jeopardy, defective jurisdiction. So double jeopardy, if you have not been previously tried for this same offense before, that's what double jeopardy is. Basically, in a nutshell. There are certain exceptions to that. But when you mention double jeopardy is you've been tried for something before and you were found not guilty, right? And now the state is trying try you for the same thing, even though you were previously found not guilty of it. Or either you had something that was dismissed with prejudice and they're coming back and trying to try you for that same offense. Do you understand?
Yes, ma'am.
State, has he been tried before for this same offense?
No, Judge, there has been no actions on the indictment, or the indictments that are pending against him. And as far as I know, he's not been charged by any other jurisdiction regarding this.
And there has never been anything pre-indictment that was dismissed with prejudice with regards to these cases? All right. Does that address that issue for you?
Yes, ma'am.
All right, then the next one, deceitful corporate veil and trumped up judiciary immunity is fatally pierced. I do not forfeit my privileges and immunities under the 4th and 14th Amendment. What I can tell you is during a jury trial, when the state calls their witnesses, your attorney will have a chance to cross-examine those witnesses. The rules of evidence do apply. If she finds that there is some question that is objectionable and should not be answered, then she will stand up, make an objection. Normally, the objections may be hearsay, entering the province of the jury, assuming facts not in evidence. It could be relevancy. It could be 404B. It could be any of a number of objections that she can make. Once she makes those objections, I will make a ruling, and my ruling will decide whether or not the witness can answer that question and whether or not the jury can consider it. Do you understand?
Yes, ma'am.
All right, does that address that issue?
Yes, ma'am.
I think the other issues deal on the second page, deal with the state bar, and I think the courts address that.
Okay,
The other one is the gross advertising negligence of the DA's office
okay.
and defendant being sued,
Oh, who's being sued?
the defendant.
All right, so, sir, there are different type of suits. There are civil suits, so technically somebody can be sued civilly for something. Sometimes with criminal cases, people will say, oh, it's a suit. Technically, it is sort of a suit, but it's, again, the state of Texas versus whoever the defendant is. You understand?
Yes, ma'am.
All right, do you have any questions about anything else?
Mm.
Okay. And then the next page, page 6, it has postscript. Is there something in there that needs to be addressed? I think it says here, it has to do with cross-examination. And then he say the plaintiff is in harmless artificial corporation. Are you talking about yourself or the state of Texas? Okay. All right. So whether or not it's a fishing expedition or a corporate entrapment or a Ponzi scheme, that'll be something that will be decided during the jury trial, okay?
Yes, ma'am.
All right. All right, is there any other motion that needs to be heard?
Anything else?
No, ma'am.
Any other jurisdictional arguments that raised that we have not talked about and the judge has already ruled? Anything other than
No, no.
All right, is there anything that you don't understand about the jury trial process?
Mm.
All right, so I will still give you a choice. If you want a jury trial, you can have a jury trial. If you want a bench trial, if the state agrees to the bench trial, then we can have a bench trial. As I've told you before, if the state presents evidence that proves you guilty beyond a reasonable doubt, that means each and every element, I'll find you guilty. If they don't, I'm going to find you not guilty. You understand?
Yes, ma'am.
All right, so if you still want a jury trial, Norma, is he already scheduled for jury trial?
Not scheduled for yesterday, Judge.
All right, so, counsel, you're still requesting a jury trial? All right, Norma, if you can put them on the jury trial, please, and Ms. Galloway, if you confer with the defense on a jury trial date, so they're gonna get a jury trial date, okay?
Thank you, ma'am.
Oh, you're welcome.
As the hearing concludes, the legal result of the session is unmistakable. The court has established jurisdiction, addressed each motion in sequence, and denied the requested ex parte relief. The judge clarified that the state bar is not prosecuting the case, that double jeopardy is not implicated, and that the indictment for aggravated robbery lawfully supports the court's authority to proceed. She also affirmed the defendant's constitutional protections, including the right to a jury trial, the right to confront and cross-examine witnesses, and the right to raise evidentiary objections through counsel. Notably, the judge did not dismiss the motions without explanation. Instead, she analyzed each argument carefully and ensured that the record reflects a clear and complete ruling. This measured approach demonstrates how courts resolve complex jurisdictional disputes by relying on established law and procedure rather than emotion. With jurisdiction confirmed, the matter now advances to the next phase, a jury trial, where the burden rests on the prosecution to prove guilt beyond a reasonable doubt. That stage will center entirely on evidence and legal proof, and it is there that the substantive contest will unfold.